Anyone having business before the King's Justice in the Superior Court of Justice, attend now and you shall be heard. Long live the King, the Honorable Justice Fighting. You may be seated.
Good morning, all.
Good morning.
So.
Yes.
Who's on first?
Morning, Your Honor.
Good morning.
What will be on second any moment?
So, Your Honor, I just wanted to start by closing the loop in respect of the discussions that happened at the end of the day. I believe it was Friday in respect of Mr. Shackers. And I will inform the court that we've had discussions. Ontario made a proposal to my friends in respect of getting the documents marked as trial exhibits on the condition that we could put the documents to a witness to provide context with some additional documents as well to provide the context we say is necessary for the court. My friends and I haven't been able to work out the terms of that arrangement, and accordingly, my understanding is that that brings the matter to a close. So we wanted to make sure that the court had that information to close, as I say, the loop on the discussion.
The close being that there's no further discussion of documents.
That is my understanding.
Thank you.
Look, my friend has gone a little bit further than I hired the court. I thought he was going to go. He's tried to provide some justification that suggesting that what Ontario did was reasonable. I didn't want to get into the debate about whether they did was reasonable or not. My suggestion at this point is that Ontario sent me a letter on June 11th explaining why they thought the matter was, what their conditions were. I responded on June 13th advising why I thought their conditions were unreasonable and unfair. And if the court wants those letters, we can provide them to the court for the court's information, or we can just leave it that there was no agreement on the issue. I'm troubled that I don't want to leave the impression that the plaintiffs rejected any reasonable proposal. So I don't know how the court wants to deal with that.
Given the non-specificity, in my view, of what I heard from Mr. Rankin, I would not come to any conclusion about reasonableness on anyone's part. So I took it as relatively neutral, and I will leave it that the matter of documents is no longer, even amongst counsel, is no longer alive.
Okay.
If I have that right.
Oh, this microphone is not on. Okay.
Okay.
Hello.
Good morning, sir.
So today Ontario intends to call it, is calling its second last witness, Eric Angel.
Can you please state and spell your name for the record?
My full name is Eric David Angel, ERIC-DAVID-ANGEL.
Thank you. Do you solemnly affirm that the evidence to be given by you to the court touching the matters in question between the parties shall be the truth?
I do so swear.
So thank you. Before we start with Mr. Angel, I'd like to enter a document as a number exhibit. We will then enter the report as an exhibit through Mr. Angel. So the document that I'd like to enter with everyone's consent, which I believe I have, is the expert qualification of Eric Angel, and agreement as to the admissibility of his reports. I'm not sure what the exhibit number would be. Yes,
Okay, that would be 86.
and is everyone agreeable to it being a numbered exhibit?
Thank you very much.
Yeah, so let me give you a physical copy.
Oh,
Yeah, we'll get the other physical copies.
Thank you.
Are there
Sorry, what-
physical or electronic copies for council?
Yes, the electronic copies you have in the email that we sent to the court some time ago, and the physical copies will be provided to you now.
Well, the court didn't get an electronic copy of the qualification statement.
I did.
Yes, we did.
Oh, they did, you did?
Yes, yes.
Oh, okay,
Yeah.
sorry.
So the agreed statement is that Mr. Angel will be qualified as follows, and I quote from paragraph 1 of Exhibit 86.
Yes.
An historian qualified to provide opinion evidence regarding the history and operation of the investments and accounts administered by the imperial government, the province of Canada, and the federal government from the 19th century to 1909 in relation to or on behalf of Indigenous people in what is now Canada, including the types of investments and accounts that existed with respect to the Robinson Treaties of 1850 and to the First Nations who were beneficiaries of those treaties, how interest was paid on those accounts, and the authority First Nations had in managing funds within those accounts. So I'll now take Mr. Angel through a brief summary of his qualifications, obviously just to give the court a flavor of what his qualifications are. So Mr. Angel, if you could look at, does Mr. Angel have a copy of the qualification statement?
Yes.
Sorry. Okay, great. If you could look at paragraph 2 of the qualification statement, you'll see one report listed entitled, quote, "The Indian Trust Fund and the Administration of Annuities under the Robinson Huron and Robinson Superior Treaties." Do you see that?
Yes, I do.
And did you author this report?
Yes, I did.
Okay, I'd like to enter this report as Exhibit 87.
Thank you. Council, are you content that it be a numbered exhibit at this time?
Mr. Angel's report.
The report?
Yes.
Yes.
Yes. Yes.
And
I'm just checking
Oh,
the
sure.
one I marked. Is June 30th, 2022.
correct.
Thank you.
Mr. Angel, this has been asked of the other witnesses who have filed expert reports in this case. Do you waive copyright on your report?
Yes, I do.
And have you prepared demonstrative slides for your testimony?
Yes, I have.
Okay, could those be distributed, please?
Thank you.
Did you author these demonstrative slides?
Yes, I did.
Could we have the demonstrative slides marked as Exhibit 88? Everyone agreeable?
On the demonstratives, it's a little bit different. I received notification last night around 9 PM from my friends that they had 3 additional documents that they intended on taking their witness through. And I don't know if that's included in
Oh,
here,
sure.
in this document or not, and I haven't had a chance to review it, so perhaps if my friend can advise me in the court whether there's anything new in this that is not already in the report.
Sure, happy to do so. So I'd just like to advise the court that the demonstratives do not contain any of the 3 new documents that were provided to my friends last night. The only other thing that is in the demonstratives that is not in Mr. Angel's report is Exhibit 75 that my friends had shown to Professor Bodway a couple of weeks ago. The court might remember that it's an excerpt from the Six Nations trustee account, certain investments.
Thank you.
Yeah, well, we have a problem with that,
That-
that perhaps we can deal with in the absence of the witness.
Okay, so should we mark it as a lettered exhibit now and then as I
Yes,
say,
please.
promote it if that works later.
Sure.
And so what would the lettered exhibit be? CC, thank you. Demonstratives? I do not. Thank you.
Oh, sure.
Very much.
Thank you. And I believe Mr. Schachter asked that the witness be excused so we could discuss Exhibit 75. Would you like to, should we do that now?
Up to you.
Yes,
Up
that
to-
would be fine.
Okay, so
We're going to ask you to, the court officer will take you out if you follow him. Thank you.
I'll give Mr. Schachter a moment to review and he can make his thoughts known.
Well, which slide, if I can ask, which slide are you intending to put to the witness to seek his opinion on an area that he didn't touch upon in his report?
Sure, let me identify the slides where this is discussed. So slide 9, 10, 11, 12, 13, 14, 15. Yeah, so from 9 to 15, and I would say 16 as well, from slides 9 to 16.
Of the letters. Well, I guess I'm surprised. This brings us right back to the issue of the documents that I had wanted admitted, and my understanding of the resolution was that Mr. Angel would not be tested.
Perhaps he's Dr. Angel. I'm
Yes, I
not sure.
apologize, yes.
Well, Mr. Lipton was of the same.
Yes, I think it is Dr. Angel.
I know we had some weeks ago a brief discussion of it. Mr. Angel does have a doctorate.
Yes.
But he prefers to be referred to as Mr. Angel.
Thank you very much for that. Okay.
Okay. Dr. or Mr. Angel, I thought the way that we had resolved the issue of the documents that I had suggested would go in was that they were not going to go in and that Mr. Angel would not be testifying to the subject area outside of his report. And so the whole purpose of my concern, and it remains now, is that experts are not supposed to testify to areas outside of their report without providing notice that they intend to do so, and providing a copy of the report so that counsel is not taken by surprise, and so we can prepare for a cross-examination. Now, the condition that my friends imposed on me or sought to impose on me with respect to the body of documents that I had suggested might go in was that I had to agree to them putting to their witness a new area, meaning the pre-1850 investments in respect of the Six Nations, and that they wanted to put to him an additional 4 or 5 documents relating to the same subject matter, which they would not disclose to me in advance unless I agreed that he could testify to a new subject area. And the first time I would see this new subject area would be indirect. I don't think that's a fair trial process. And if we have to get down to court, there are court cases that I think I might have, if we have the blue book, the statute book, I can maybe even refer to a couple court cases if I need to.
Okay.
that stand for the proposition that this kind of trial by ambush, where an expert witness opines on areas outside of his report, are inappropriate without an expert providing an expert's report. I provided Ontario with the opportunity. I said, look, if you want to have him speak on this area, he has to produce a report. And I suggested, you know what? Why don't you tell me what facts you want to prove through this witness in respect of the new area? And perhaps I will agree. Ontario refused that offer as well. So here we find, surprisingly, that my friends now wish their expert to testify to a new area outside of the scope of his report, without a report, without an opinion in advance, that leaves the plaintiffs in a very unfair position of not being able to know what is going to be testified to, not being able to prepare, and our case is closed, and to suggest to us that, well, maybe if something comes up, you can have Sir reply, is a little bit late in the day. And I would say my position is that this witness can't testify to areas outside of his report. He specifically chose not to comment on the Six Nations accounts, although he obviously knew
He
about.
specifically, Mr. Angel?
Yes, Mr. Angel or Dr. Angel specifically chose, I'm presuming because he lists the accounts of the Six Nations as one of his areas of reports.
Mhm.
I'm specifically, they must have made a decision at some point not to go into that. And now to sort of go into it on the fly in order to deal with other evidence that was not put to, was not going to be put to this witness, and was not going, I did not think was going to be a subject area that this witness was going to deal with. And for them to raise it at this point is unfair without an expert report being filed.
And
And it's
could
probably too
you,
late for an expert report to be filed, I might add.
right, and could you identify, I did not keep track,
It
can you
was-
identify those slides which
It's
are an
slides
issue?
9 to 16. I haven't even read them yet. I don't even know if I disagree with them or not. But it's my object, we can take a break to see if practically I have any dispute with them. And to see if they're contentious, because I think I have a good handle on the facts regarding the Six Nations accounts. And maybe we can try and deal with it that way, and we can just let it go in by agreement if or we can see what can go in by agreement. That's a solution too.
Okay, well, it's an obvious first step.
Yeah.
And just to be clear, you say, having had the slides identified by Mr. Lipton, you say slides 9 to 16.
Mr. Lipton identified slides 9 to 16 as the ones involving the Six Nations accounts. I haven't even verified that yet.
Okay. But should they be the Six Nations accounts? You say the Six Nations accounts were not addressed in Mr. Angel's report.
Correct.
They were raised by you
That's correct.
in, not through a witness, I don't think, or maybe through a witness, but in any event, in representations here, that there was some discussion last day and continuing about how to deal with those, because as I recall, you wanted to look at them, you asked for them.
Right.
And you say that that discussion went nowhere.
That's correct.
And I'm not sure that I need to know why at
Yes,
this point, but it did not result in a resolution. And now Ontario seeks to put documents that were not the subject of any opinion or any comment in the report into evidence through Mr. Angel,
that's
through his
correct.
demonstratives, firstly through an exhibit and presumably secondly through oral testimony.
Correct.
Do I have that?
Yeah, he's going outside of his report, and that's not permitted.
Mr. Lipton? Unless you think it's worthwhile having the break first before you respond.
You mean for Mr. Schachter to review?
Yes.
That's fine with us.
Well, I'm just wondering, you may know what's in those documents
No,
better
it's
than
fine.
I.
I can speak to the matter.
Okay, go ahead.
So the court might not be surprised to hear that we view this a little bit differently. You'll recall that when Professor Bodway was on the stand on May 30th, I believe, he was shown these documents for the first time. So the first time this document, Exhibit 75.
Okay, so Exhibit 75 is what's in slides 9 to 16?
What is referred to in slides 9 to 16, yes.
Okay,
So you'll recall that on or about May 30th, my friend showed Professor Bodway Exhibit 75, which is an excerpt of part of some of the Six Nations accounts. And this is not a document that we had heard about from our friends before. And we found
from which friends?
from
From the plaintiffs?
from the original plaintiffs, yes.
Okay,
And we found it a little bit surprising that they would put this historical document to Professor Bodway, who doesn't know anything about the Six Nations accounts. Because I think in this case, especially, we're all aware of the mischief that can arise when historical documents are put acontextually to someone, right? You need to not understand not only the document, but the context surrounding the document. And it was plain to us, and we thought it might have been plain to our friends, that Professor Bodway just didn't know that context. He didn't claim to have an expertise in the Six Nations account. It just so happens that Mr. Angel does actually have that expertise due to other work that he has done. He actually can speak in detail about what Exhibit 75 means. And we think that given that this document surfaced all of a sudden at the end of May, and it has become part of the trial record, my friend, Mr. Schachter, elicited testimony about it from Mr. Bodway, albeit perhaps not the most helpful testimony because Mr. Bodway didn't know much about it. But Mr. Angel will be able to help the court understand the significance of this document. He has spent years looking at the Six Nations accounts, and he can talk about why they matter or don't matter to this case. So in our view, what we're proposing to do is to respond to a document that my friends provided very late in the day during Professor Bodway's testimony, put to a witness, Professor Bodway, who did not understand the document, and we're just here to provide helpful context and understanding surrounding this document, so it is not does not accidentally end up being misused by the court who wouldn't understand it unless Mr. Angel talked about it. That's all that we're trying to do. We acknowledge it's not in his report. It couldn't have been in his report. We had no idea that when Mr. Angel wrote his report in June of 2022, that my friends intended to open up a new area of discussion by bringing the Six Nations accounts into that. That was never in anyone's contemplation as far as I know. So.
okay, just if we can back up a
Sure.
bit. My understanding is that Mr. Angel either referenced or otherwise Six Nations accounts.
Yes, so I can explain exactly how.
Well, I just want to go back to your comment that would have been a surprise to you, any Six Nations accounts.
Yes,
But Mr. Angel is your witness.
yes.
So you would have read his report and read references to the Six Nations account.
So the only reference to the Six Nations account in Dr. Angel's report is when he's describing his experience. One of the things that we wanted to make clear for the court is that Mr. Angel's expertise is based on his long employment experience reading band trust accounts and working in this area. So in order to show what his expertise is, he listed just a reference, I worked on this project, Six Nations account. That's the entire reference. There's no reference to any details on it. It was put forward as evidence of his experience in the area. So there really would have been no reason, there's no other reference to it in his report.
All right. So it wouldn't surprise you that counsel on the other side would take a look at his experience and what he references.
at his experience and what he references.
Well, if you describe someone's experience, wouldn't surprise you that counsel on the other side would say, I'm going to dig into that, see what his experience is. See what he's looked at.
Sure, yes.
You'd do it.
If I had the time, I would.
So then you might discover something
Yep.
and you might put it to a witness.
Mhm.
That's not unfair.
No, I agree that it's not unfair, but it is unfair to put it to a witness, Professor Bodway, who doesn't understand the document at all.
Well, the scope of cross-examination allows that.
Sure.
It wasn't unfair to put it to Professor Bodway. He
Right.
could or could not answer. And you could deal with that on redirect. So then the next step here is you say, now we want to rehabilitate that evidence. We want to put it in context.
Yes. We want to make the document understandable to the court, and the way it was put to Professor Bodway, he plainly
He
did
said-
not understand.
You
it.
say it's without context.
Yes, he's right. So you might recall in Professor Bodway's testimony, he referenced the trustees. He doesn't know who the trustees are.
Okay.
Mr. Angel does.
Okay, but so I'm trying to get into this. So then Mr. Schachter says, I think, if I recall, supply all these documents, produce all these documents, or something like that. And you say, as I understand, somehow Ontario says, only if X, Y, Z. There are some conditions attached to that.
So I think
And is that where we are now? You say, no, I'm not going to do that, or we, Ontario, are not going to do that, but we're going to put them in now. We're going to take whatever thunder, whatever effect you were planning, and we're going to do that without letting you see them ahead of time.
So we're talking actually about a different document here than the documents that were the subject of the dispute.
Okay, then
Between the
let's
parties.
name them when we talk about them. I know one document is named Exhibit 75.
That's the only document we're talking about right now.
Okay,
So the dispute was, and I'll briefly summarize, my friend can obviously add if I've mischaracterized the issue. There were about 10 documents other than Exhibit 75, new things that were not Exhibit 75 that they said they wanted to put in.
they, the plaintiffs.
They, the plaintiffs, the original plaintiffs, not speaking, of course, to the group of 7 here. And then we said, well, there are additional documents. If you're going to try to put these in, there are additional documents we would like to put in, and we would like this all put to Mr. Angel so he can comment on them because they're within his expertise.
Right.
But that is it. As I take it here, that's not what we're talking about. The only thing that my friend is objecting to
Yes.
is Mr. Angel commenting on Exhibit 75, which is already in evidence that was adduced by Mr. Schachter.
Oh, no, it's not. It is in evidence. You're saying Exhibit 75 is in evidence, and
Exhibit
you want
70
him to comment on it.
Yeah, so so none
Okay, just
of,
let me slow down.
yeah, sure.
You want him to comment on Exhibit 75. I think I got this.
Yeah.
Even though it's outside the bounds of his report.
Correct.
All right.
So that the court
And
actually,
you say that's permitted under the rules how?
well, I mean, there would be several reasons. Witnesses can comment on the testimony of other witnesses, so he would be commenting on the testimony of.
What about the rules about expert opinion?
So the rules of expert opinion generally require notice, right,
Yes.
in the form of a report.
Yes.
We can't satisfy that requirement. We've provided the slides. That is a form of notice. Obviously, it's not much time.
But you didn't ask for leave.
No, if you think this requires leave, I would ask for leave. Yes.
But would you not agree that it requires leave? You're asking an expert to give an opinion or comment as an expert on something outside the bounds of his report.
Yes.
So seems to me you're asking for an indulgence,
Well,
but it didn't sound like that at the beginning, nor does it sound like that's the approach to the plaintiffs. That it's Ontario asking for the indulgence.
well, I mean, I suppose we are, but only to respond to this document that my friends put in that the court, I don't think can fully understand without proper testimony.
Well, you may have great grounds to ask for an indulgence,
Sure,
but it's always better to start like that.
fair enough. Well, we would, if that is how the court views it, we would ask for leave to put this in if leave is required.
Well, leave for, it's not just putting in a document. What the plaintiffs don't have is Mr. Angel's opinion.
Yes, although it is set out in the slides
Right, so when did they get that?
just now.
That's hardly notice.
I agree it is not much notice.
So that's the indulgence. You are asking for the indulgence to put in those slides,
Yes, and Mr. Angel's testimony on them.
right? So it makes sense for the plaintiffs to take a look at those and see what their position is on that request.
Okay.
All right. How long do you need? Or have you looked at them?
Can I ask for 20 minutes?
All right, let's do it. Thank you.
All right. This court will stand in recess for 20 minutes.
Order, all right.
This court will now resume. You may be seated.
Excuse me. Excuse me. Yes, sir.
If it may please the court, thank you for the 20 minutes to sort of consider our position. And I'm afraid that the solution of simply allowing what my friends want to, having the slide is going to cause problems, and I wanted to explain my position. And I think since we're dealing with a request to in effect proceed with a report that have only seen what my friend has classified as notice of an expert's report just moments ago, I'm resisting that. I want to give the court a little bit more context and so the court can make its decision with a fulsome picture. First, I note that of the 45 slides that my friends have provided, 8 of them, or approximately 20% of their slides, involve the Six Nations accounts. My friends have known about the issue about the Six Nations since early May 2023. It's been about 45 days. And as the law would have it, what is provided in these slides are really just conclusions. And the law is clear that a conclusion is not a report. And then for that, I refer to the case of Hearn, Hearn versus Maslak, Maslak.
Sounds like a Sudbury case.
2018 ONSC 945, where it says the trial judge refused to permit an expert to testify because his late served one-page report merely stated his conclusions. Virtually anything he said in oral testimony would take the opposing party by surprise. And I just happen to have an actual one copy of that Hearn case, and at paragraph 11, you will find that reference where the judge, and it was Justice E.M. Morgan, said, it is evident from a review of Mr. Bremer's one-page expert report that virtually anything he says in oral testimony about the painting an issue will not have been anticipated from a reading of his report and will therefore take counsel by surprise. And this witness was not allowed to testify on the basis of conclusions, not a report. The Next thing I wanted to advise the court about is that an expert's report must set out the expert's opinion and the basis for that opinion. And that is a well-known statement from Marchand, Marchand versus Public General Hospital. 138 Ontario Appeal Cases 201. And what we have here is we have a situation which, and I said, it brings us back to a whole new can of worms being opened up. That, again, if the witness is going to get into, I note, for example, that part of the slide talks, I think, about excuse me. Yes, talks about a number of the documents which my friends just said could not go into evidence. Remember the documents that we were talking about going in included not just the 10th statement, which is in evidence as Exhibit 75.
What's it called? The what statement?
The statements of account between the trustees for the Six Nations of Grand River and the Six Nations.
How did you shorten that?
Statement of account. Oh, 10th statement.
10th statement. Thank you.
Yes, yes. So there were at least 10 statements, probably more. I could only uncover, I think 1, 5, 6, 7, 8, 9, and 10. Anyway, I found them in the archives. I suggested they go in by consent. My friend said, no, you can't, that can't happen. And at this point, because we are dealing with a contested motion, I think it's important that the court understands the reasonableness of the plaintiff's position as to why we object to this witness being able to testify without a report. And this is actually contained in the letter I provided to my friends on June 13th, yesterday, in response to their June 11th letter. And if it would be easier than me simply reading from it, I could provide the court with a copy, which I brought today, which I'd like to do.
Is there any problem with this?
No.
Thank you. So let me see if I've got this. The correspondence you're showing me has to do with your request, plaintiff's request of Ontario to allow in on consent certain documents, including the 10th statement.
Well, it involved Ontario's conditions. They said, look, we will allow those documents in, but only if, I'm going to read from my letter. And this is why I thought it was unreasonable at part F. 1, your expert does not have to prepare or provide us with, or the court with, an expert report outlining his opinions in respect of the new documents. That's one of their conditions. I thought that was wrong. 2, you do not have to provide us with advance notice of the facts you wish to prove through the witness. I thought that was wrong. 3, we are required, that's the plaintiffs are required to consent to Ontario being able to lead their expert witness to give new opinions in relation to new documents, and which opinions we will not hear about until he testifies in direct. I thought that was wrong. And 4, they can put to your witness any of the documents we discovered, that's the plaintiffs discovered, as well as 4 or 5 additional documents that Ontario is refusing to disclose to us. which I still haven't seen. And I said in the letter, the unfair manner that you are insisting the documents are tendered leads us to be concerned that the probative value of the new documents is likely to be outweighed by the prejudicial effect you seek to impose. We cannot in good conscience accept your proposal. And at paragraph G, I advised that there were options. And I reminded Ontario that you will recall that Mr. Lipton observed, and this was in the case management conference, that Ontario would not be able to lead evidence from Dr. Angel on the proposed new documents because it was not part of his report, and this would result in unfairness to Ontario's position. Now, we offered two solutions that we thought might be agreeable, and Ontario rejected both of them. The first was to ask you to identify what facts you wish to prove relating to the new documents. If we knew in advance of what those facts were, we might be able to consent to those facts going in by agreement. That was rejected. And the second solution was that we asked Dr. Angel to provide in advance a draft report setting out the opinions he wanted to give. With the draft report in hand, we would be able to assess whether permitting him to testify on the new subject would be unfair to us. We would, in effect, be able to assess the probative value of his new report and consider whether there was any prejudicial effect at all, and if there was any such prejudicial effect, how we might fairly be able to respond. That, I thought, was a reasonable approach that was not accepted by Ontario. And with that history in mind, I was quite surprised to find that my friends were intending to go into the very topic that they said their expert could not and should not go into. And I would invite my friend from the group of seven to add some comments if I've missed anything, but that would include my submissions as to why the slides involving Exhibit 75 should actually be ripped out of Exhibit CC and the court should not review them, and that Ontario should not be given permission to allow this witness to testify in this new area outside of his report, which they knew about for, well, I guess I would put it this way. If these documents were relevant, they should have been produced years ago.
Thank you.
Good morning, Your Honor.
Good morning.
I adopt the submissions that you've just heard from Mr. Schachter. In my submission, it's a question of notice at a very late stage in the trial, and it is unsatisfactory for these new slides to deal with something that goes beyond the expert report and for us to receive this at this stage. Thank you.
Thank you. Anything further, Mr. Lipton?
I do. So, one thing,
Go ahead.
one thing I would like to just remind the court of from my earlier submissions is we think Mr. Schachter's discussion of the other documents is a bit of a red herring. Forgive my Norwegian, I don't know the phrase.
Other documents,
Yes, so
Exhibit 75 or beyond.
exactly. So we see a very clear difference between Exhibit 75, which is the subject of the slides that we're talking about, and all these other documents that my friend seems to insist to want to talk about, even though that's not really the subject of what we're trying to put into evidence. One of the things I just like to do, because my friend offered his letter to the court of this side discussion, I just like to hand up our letter
Thank you.
just so that the court can have that additional context. And so this was the letter that we wrote in response to my friend's request to put these 10 new documents into evidence. Their initial request was to put them in just bare documents all by themselves with no explanation whatsoever. As I've said, I think the court is well aware of the danger that can come from misunderstanding historical documents that are provided without context.
Would it, it would be helpful to me if you would simply make your submissions at the moment, unless I really need this context, on your request that Mr. Angel testify on matters involving Exhibit 75 that are found in slides 9 to 16.
Sure, I can definitely focus on that. I would just request that to the extent the court cares about the other issue, it would review our letter.
Okay, I will.
So focusing on the request to put in Mr. Angel's evidence, his slides, and then his testimony, and any cross-examination testimony that might be elicited on the Six Nations topic. I just note that in our prior discussion, the court had suggested that this was a leave issue. I would say that is certainly one way to approach it. I would just bring to the court's attention the case of Cheeseman, Cheesman.
Yes.
And the neutral citation is 2019 ONSC 5783. And I'll just quote from a portion of the Cheeseman case. It is also common that evidence may develop at a trial in a way that was not evident when the reports were written. Quantrell and Marchand rightly allow the defense expert to respond on the stand in those circumstances. There are no doubt other circumstances in which it would be appropriate to allow defense experts to testify to a point, even if it is not contained in their report. Just for the court's information, when the court reads this case, Quantrell and Marchand are both Court of Appeal decisions that stand for the proposition cited in Cheeseman here. The point being that we can, and I will make submissions on leave, but it is not necessarily a leave issue. It's an issue of one expert responding to evidence that was provided. And so that is one way to look at it, but I fully accept.
On a question, what was the question that the court was dealing with?
The question was whether or not it was appropriate for one expert to respond to the testimony of another expert. So sorry, I should set this out a little more clearly. There's a plaintiff's expert had testified to a subject on the stand.
Mm-hmm.
And then the defense expert went on the stand, and their counsel wanted to elicit testimony from the defense expert
Mhm.
that responded to the plaintiff expert's testimony.
Yes.
However, the subject that the defense expert would have been testifying about was not contained in that defense expert's report. They were responding to a sort of a fresh area that the plaintiff's expert had raised. So that is the factual context in which this statement was made.
Was the plaintiff's evidence on that particular point
Correct, yes.
outside of the plaintiff report?
I am not certain about that. I don't know.
You used the word fresh evidence.
Yes, so it was something that from the case that the plaintiff, that the defense expert would not have known to have previously responded to.
So it suggests that it was outside the plaintiff's report.
It could well be. I don't want to misstate
Okay.
the case, and so I'm not.
But doesn't it
certain.
sound like that? If he could not have anticipated?
I imagine that could well be the case, but I just don't want to
Okay,
agree
so-
because I'm not sure.
But you say the case stands for the proposition that an expert, a defense expert, can reply to a plaintiff's expert on matters that the plaintiff's expert testified to that the defense expert could not have anticipated.
I think it stands for that proposition, but also a broader one. And
Okay.
it's not a defense plaintiff's things. I think
Right.
I would say it's bidirectional.
Right.
But the idea here being that evidence can develop at trial in a way that's unexpected, and it could not have been anticipated when the reports were written. And so when something like Exhibit 75 suddenly surfaces and is put before Professor Bodway, who understands it not so well because he knows nothing about it, that is a new circumstance that calls for a response and that Mr. Angel should be able to respond to it to provide context to the court so the document can actually be properly understood. That's the proposition that I think this case stands for. And if the court were to look at Cheeseman and Cointreau on Marchand, you would see that.
And how do you spell Cointreau?
Sure. Cointreau is Quantrill. That's a Court of Appeal case, I believe, from 1978. And my friend previously spoke to the Marchand case and gave the
Yes.
citation. That's a 2001 Court of Appeal. I don't have the citation with me. So all of which is to say, this is all under the heading of it isn't necessarily a leave issue. Now let me address leave
Okay.
briefly. Okay, so the leave rule, as we know under the rules of civil procedure, is rule 53.08 sub 1. And one thing that I'd just like to draw the court's attention to, because this rule was recently changed in 2022, and just want to make sure everyone's on the same page. Before the change in 2022, the way the rule was stated is that leave shall be granted. And then there were certain sort of qualifications stated to that.
Mhm.
The new statement of the rule is that leave may be granted. So I just want to make sure that we're aware we're working with the appropriate legislative language that exists now.
So you say the wording of the rule is leave may be granted.
That's correct. It used to be
Thank
shall,
you.
it is now may.
Thank you.
Okay, and so in order for leave to be granted, the party responsible for the applicable failure, that would be us, must satisfy the judge several things. First, that there is a reasonable explanation for the failure. We believe that there is a reasonable explanation here. We did not know that the Six Nations report, which is the Six Nations not being a Robinson Superior Treaty Nation, would come before this court and be offered as potentially relevant evidence. And contrary to my friend's suggestion, we did not know this in early May. We only knew this when the report was in fact put before Professor Bodway on May 30th or 31st. So as soon as we learned about that, we thought about what could be done about that. And we came to understand that Mr. Angel knew about the Six Nations account. Obviously, my discussions with Mr. Angel about this topic have been a little bit strained by the fact that I have a conflict on the Six Nations case. But I've come to understand that he does have a knowledge of the Six Nations accounts. So that's why we could not have done it earlier. So we have a reasonable explanation for the failure to provide earlier notice.
Well, but even earlier than today, obviously you've been talking to the witness possibly since May 30th. I don't know when, but you're only giving it to the plaintiffs this morning.
Sure, so I can speak.
So and plus we didn't sit for, a number of days. So all of that seems like, it almost seems deliberate. We're not going to give it to you in time for you to do anything.
I can understand why it might be seen that way. The difficulty is, as you know, Mr. Angel's personal circumstances have remained difficult. I've had a very difficult time getting a hold of him because his family members, all of his close family members are having very hard times. So we haven't had the normal sort of communication that you would expect, easy and frequent communication with experts. And so, to be honest, it was only when Mr. Angel finally arrived here on Saturday that we finally began a discussion of this issue, and it took some time for him to do the research he needed to do to write what he did. So, we regret that it could not have been provided earlier, but I would hope that the court wouldn't view it as a deliberate withholding of information. So the next thing that must be proven for leave to be granted is that granting leave would not do either of these things. So you have to show that neither Roman sub 1 nor Roman sub 2 would occur. So I'll start with Roman sub 1. I'll just read the legislative language and then discuss it. So I'll read the opening flush as well, so it makes sense grammatically. Granting leave would not, 1, cause prejudice to the opposing party that could not be compensated for by costs or an adjournment. So in our view, the prejudice to the opposing party, being the plaintiffs and the group of 7, is not too significant. We're talking about a document that the original Red Rock plaintiffs themselves offered into evidence. And we think that when a party offers a new document into evidence, as we were discussing earlier, in terms of what counsel might reasonably expect, they might expect that there would be a response to that document. And so here,
But they couldn't have expected any conclusions.
any conclusions? Sorry.
Well, the evidence in dispute is Dr. Angel's evidence.
Correct.
It's not the document. Exhibit 75 is already in.
Yes, but he's commenting on it.
So they can't expect what he might say on it. They don't know.
No, but they could reasonably expect a response, right? That we would not have simply allowed a historical document contextually put before the court, right?
All right.
Because what is currently on offer, Exhibit 75, with no explanation, and the court is invited to draw inferences from it, which we know can be quite dangerous in a historical context. So that is the mischief that we hope to address through Mr. Angel's testimony.
But I do see a clear distinction between your statement. They could have anticipated our response versus they could anticipate what Mr. Angel's response would be. They can't anticipate that because he's never commented on it.
Yes, that's right.
So you have it. You don't show it ahead of time. Doesn't sound to me like they could have anticipated anything. Anyway, that's not an anticipation they could have had, something reasonable. That they could have anticipated a response, then that we would have ended up in this situation. They might have anticipated that, but that's just a workflow issue. That's just how do they spend their time? But not the substance. Okay, go ahead.
Sure. And so we think whatever sort of prejudice that they might suffer from this is diminished substantially by the fact that they have the opportunity to cross-examine Mr. Angel. Mr. Angel is here. He is knowledgeable on the subject, and he can be cross-examined extensively. I know my friend, Mr. Schachter, loves a long cross-examination, and Mr. Angel is available for that should it be necessary.
Anticipating someone's love is always dangerous.
I've learned that in my life.
Okay.
And then in terms of whether or not it could be compensated by cost or adjournment, I don't think my friends are asking for an adjournment. And costs obviously will be in the court's hands on that one. The other thing that granting leave would not do in order to gain the leave is cause undue delay in the conduct of the trial. So here, what we're proposing is that Mr. Angel will testify today in direct examination to this issue. The plaintiffs will, I'm sure, actively listen to his testimony, and then they will have the evening and the morning, and then they will cross-examine him. I don't see much delay from that that's how it would have occurred. In any case, the cross-examination may be longer. So those are my submissions on leave, unless the court has any additional questions.
All right. Thank you.
Thank you.
Anything else? Canada, are you participating on any of this?
No, we're not. In fact, we support Ontario's position, but will not be making further submissions.
Thank you. Mr. Schachter.
Yeah, if I might be permitted to speak, my friend in effect has split his motion and referred to a number of cases that I didn't get an opportunity to respond to. In particular, the case he referred to does not stand for the proposition he proposes.
Which case?
Yeah, I'm
Cheeseman?
just going to get it, the Cheeseman case. My friend left off the the beginning of paragraph 76. And I think perhaps the court got it, but I just want to make sure that that's the case. Paragraph 76, the judge says, I agree that there are circumstances in which it would be appropriate for defense experts to respond to the evidence of a plaintiff's expert, even though the defense experts have not included that information in the report. And I would agree that if I had experts that went outside of their report, it would only be fair for their expert to comment on it. That's not the situation we are in. And indeed, I don't believe the Quantrill or the Marchand cases would support my friends either. I tried to take a quick look at those cases, and I don't believe that they are applicable to this situation. And my friend also left off paragraph 77 of the Chessman case that said, however, it cannot be the intention under the current rules to allow a defense expert to be silent in his report about a critical issue and spring that evidence on the plaintiffs after the plaintiffs have closed its case. That is the situation we are effectively in right now. The second thing is my friends, in their explanation as to why there was a reasonable explanation for the delay, neglected to address the fact that whatever Mr. Angel's personal situation may have been, the plaintiffs have been banging at the door for over a month and a half at this point, trying to get at those an explanation of the Six Nations documents. And we have been banging on the door and have been rebuffed. And now we find ourselves in a situation of looking at the slide deck and seeing that it is not an expert opinion that is based on, that provides an opinion with the reasons for that opinion, or a description of the factual assumptions, a description of the research, or a list of every doctrine relied upon informing the opinion. It is simply a conclusion. I rely on Rule 53.03 sub 6 for that proposition as to what an expert report must include. And I guess I would disagree finally with my friend's views that contextualization is necessary for the court. I think where we're left with now
I'm
is,
just going to slow you down because this would be the subject of my question.
Yeah.
Am I left from the cross-examination of Professor Coates? Am I left with,
Bodway?
or Bodway, am I left with incorrect conclusions or
I don't think you are, but my friends do, and no doubt in argument, they would argue you should give little weight to that. But I had said, and I in open court last week, that I believe that with that Exhibit 75, together with the comments in the Bagot Commission report, which is already in evidence, I can make my point as to investments available prior to 1850. To the extent that it's relevant, because I mean, there was no annuity augmentation prior to 1850, but to the extent that it's relevant to say what was out there and available, it's there. And I don't think it's working in unfairness to my friends, or I might say, and most importantly for me, I don't think it's misleading the court at all to allow Exhibit 75 to go in without editorial comment from an expert, especially since the proposed slides raise up a whole new set of issues, leading to a whole additional set of documents, one of which is the issue of the Grand River Navigation Company, which is talked about in the Bagot Commission report already, but leads to whether or not that was a good investment or not. There is litigation already outside of this court case where Ontario and Canada are taking the position that those investments were reasonable and prudent investments at the time. And now this witness is going to talk about why they weren't prudent investments at the time. And so that means if this evidence would go in, then I would have to start bringing in the evidence from those other court cases and the pleadings from those other court cases and putting it to a witness who perhaps doesn't know what Ontario's and Canada's formal position is in the Six Nations litigation that is going to trial in about a year. We are going down a little bit of a rabbit hole if we allow this witness to testify to a partial explanation of the Six Nations issues. So at this point, so late in the day, the evidence should not be permitted, and that is not prejudicial to a just determination on the merits.
Let me just remind myself, and if I get this wrong, I'll ask you to help me. The evidence is with respect to either the, or perhaps the ability of First Nations to invest. Is that right? Is that what it speaks to?
It's the investments that were made by the Six Nations. And if the issue is whether or not after 1861 such investments were common or available, I can advise the court that the record, I think, in the Bagot Commission suggests that they were not. This is not something that I would suggest to the court was the case. But prior to 1861, it's less clear from the Bagot Commission report. And there's nothing in the record that I'm aware of that would suggest that investments outside the trust accounts could not go to England, right? And this is the point that I'm going to be using it for in argument that up until 1861 it was possible. Up until after 1850, it may have been possible, but I won't even argue that it was likely, given the way the trust accounts were operated, as set out in the Bagot Commission report. But I will argue that money that was paid out by the Crown could be invested anywhere in the world. And the fact that people were investing in England in stocks and bonds is a relevant consideration in deciding, what kind of interest rate could be earned. That's
Right.
why it's relevant.
So can I just want to step back because
Yeah.
that's possibly a bit too much for what I'm focusing on.
Could I just address the one question you asked about whether or not the court would be misled? Because there's a precise piece of information.
Yes, I will but not now.
Oh, sorry.
Just hold that thought
Yeah,
if you don't
sure.
mind. So this evidence is relevant for your purposes
Yes.
on the question of whether First Nations could make investments outside of Canada. Is that what you're saying?
Or indeed, if anyone could make investments, and you might recall, I think, Professor
Outside of
Bodway's-
Canada? Was that the
Yes.
question?
Well, Professor Bodway's outside of Canada and in stocks and bonds and other investments aside from consols or aside from bonds. And you might recall Professor Bodway's evidence was that he was, I think, or someone's evidence was they couldn't invest in such instruments. And so the issue is, well, whether they could invest in such instruments through the trust funds is a different issue than whether they could invest it generally. And access to capital markets was an issue, a question we've put in evidence now that such access was available. Whether, I mean, maybe it's for the court to decide, what would have happened. But the issue of whether we feel we've proven to the extent that it's relevant for a final determination, we feel we've proven that such investments existed and were being accessed by Aboriginal people prior to 1850, and that reasonably could have influenced or been in people's minds prior to 1850 at the time the treaty was made.
Thank you.
But this is for argument, and that's the purpose in which
Yes.
I was intending it.
Prior to 1850.
Yes, and that it would continue to be available as well. Again, after 1861, outside of the trust accounts, and prior to 1861 and after 1850, it would seem to me, and I'll say this in argument and I'll say it now, it would seem to me, given the way the government conducted itself, probably unlikely the government would have chosen to invest outside. But I believe that'll be found in the Bagot Commission report.
Okay. Mr. Lipton.
So just a very brief and precise statement
Yes.
about whether or not the court would be misled. And of course, I want to start by saying, I don't think anyone's trying to intentionally mislead the court. I think that's quite apparent. It's more that there's a misunderstanding about some of the statements in Exhibit 75. So some of the entries in Exhibit 75 refer to bank stock, quote unquote, in London. And were Mr. Angel permitted to testify about that, I anticipate that he would say that reference to bank stock in London is actually reference to consols or a form of government bond. That's what I anticipate he would testify. And so I'm concerned, even if not everything that we want him to say would go in, I'm concerned that if he can't testify to that point, the court's going to be misled about the nature of the statements in Exhibit 75. That's all I wanted to say.
And consols is CONSUL?
CONSOL.
And
And
they are,
it's a form of bond, perpetual bond issued by the imperial government at the time. I believe some are still in existence. So get your money in.
or out.
That's all I wanted to say.
Thank you. And you say in any event, no matter what the rest of the evidence is, that he should be allowed to explain what bank stock in whatever years that 10th statement is. what it
Yes,
means.
just so that it's on the record in evidence correctly what this thing is. And like I said, I don't think anyone's trying to mislead anyone, but he can clear that up.
Thank you. And on that precise point, Mr. Schachter, do you say that needs clarification?
Well, I don't know what the basis for that opinion would be.
Okay,
Obviously, if there's a conclusion stated, that's not an opinion, but, it would immediately draw to my attention, well, what about the other 10 statements that are not in evidence? Because I would suspect those probably have bank stocks in them as well. Right? And so are we now going to impugn all of the records? Is there nothing we can learn from the trust account records?
all right.
Right? I mean, I don't know where this opinion comes from. And if it was in a report, maybe I could trace it down to see if it's something I would challenge.
Thank you. I'm going to take a few minutes and look at the rule and look at the cases. And I see that it's 11:35. And we haven't had a lot of evidentiary arguments, which has meant that we have been able to maintain schedules. And I hate to say this, but Friday is not available. Right. 11. let's say, we'll try and come back at noon. I'll let you know if we can.
Overall rise. Stand to recess until 12. Ms. Goldman, I resume, you may be seated.
Thank you for that time, council. I will not let in the new slides nor questions with respect to the Six Nation accounts. Let me tell you how I see this. If one looks at the case at Cheeseman and looks at the line on which Ontario relies, which is evidence may develop at trial in a way that was not anticipated when the reports are written. And that's Ontario's position. That's how they see it. And they see Cheeseman as support, therefore, for the proposition that the evidence should go in because the evidence developed, the evidence with respect to the Six Nations accounts developed when the plaintiffs put Exhibit 75 to a witness. The plaintiffs say, well, the evidence didn't develop then. The evidence with respect to investments existed earlier than that. But there is a very strict rule with respect to expert reports, and that rule is primarily a notice provision in order to allow parties to put the best evidence before the court. And in this case, there is no doubt I want the best evidence, but the best evidence to me is evidence that is not confusing. And having looked at the slides, I see that there are opinions with no basis, with no suggestion that there was research done to compare anything. It would, in my mind, raise questions even from me without questions from the plaintiff about these accounts. And I don't see that the plaintiffs have had the kind of notice they would have used to respond to the issue. I do say also, having read the correspondence, that it appears that the conditions imposed that were sought to be imposed on the plaintiffs in order to allow them to put in some evidence were unnecessarily onerous. And that doesn't work in a case where conciliatory approaches might allow everyone to meet their own, and I won't say needs, their aspirations with respect to the evidence, because it is not immediately evident to me how important this evidence is. So I will say that Ontario, of course, has opened to it any redirect on the on evidence that is left in some way unclear or raises questions. But the way I see the new slides is that they are opinions without basis in supporting fact and also without context. So can we, so that will affect how we manage the exhibit when Ontario seeks to put it in, if they seek to promote it, as we say, to a numbered exhibit, and also how you conduct your direct. All right, thank you.
Can we bring back Mr. Angel, please?
And I dare not ask how we're doing on schedule.
yes. We might be okay. We might be okay.
I have 20% less questions, obviously.
Okay,
I think
think we've lost him.
that's right. After 2 hours of sitting outside, he just decided to go home. It's a long walk back to Port Alberni.
He starts today, he'll be there by July. Okay,
Well, sure. Before Mr. Angel returns, I think I could ask in his absence on the issue of promotion. I would ask that we be able to, when slides 9 through 16 are removed, that we
Yes.
be able to enter it as a numbered exhibit, if that is agreeable.
Again,
presumably you're going to cover it all in. in
if
chief.
it's going to be covered in chief, I have no problems with that.
Okay, so could we enter that as the next number, which is 88? 88, yeah. And please, for the court's physical copy, 9 through 16.
I'll give it to you at the break.
Oh,
and-
okay.
And you can fix it.
And could we prepare an electronic copy with those slides removed? Thank you.
Okay. Just make a note here. Okay. Please go ahead.
Sure. So we have that in as Exhibit 88. So Mr. Angel, can you confirm that you signed an acknowledgement of expert's duties and that you understand it is your duty to assist the court?
Yes, I did sign that and I understand the duties.
Because we've lost a little bit of time, I'm going to take you relatively quickly through your qualifications just to cover the main points. And I'll lead the witness here, assuming that's agreeable.
Please do. Thank you.
Yes, thank you. I see you have a BA from the University of Winnipeg in Canadian history,
That's correct.
and you have an MA from Queen's University.
Yes.
What subject? Right. And you have an MA from Queen's University.
Yes,
In what subject?
history.
And you also have a PhD from Simon Fraser University.
Yes.
In what subject?
Natural resource management.
And you have worked for the the Federal Department of Indian and Northern Affairs Canada.
No. No, I didn't work directly as an employee. I worked on contract and I had other clients at the same time.
And then later you worked for an organization called Public History, Inc. Is that right?
Yes.
And during your, and then since 2008, you've worked as the principal at Eric Angel Research, is that right?
That's right.
So in all of these employment roles that you've had, approximately how many hours have you spent reviewing band trust accounts?
I estimated around 2,000 hours over that entire period of time.
And what do you say that period of time is?
From 1993,
Okay.
April to present day.
Thank you very much.
Okay, so that's what I'll do for the qualifications, and we ask that Mr. Angel be qualified as an expert as set out in exhibit, I believe it's 86, the agreed qualifications.
Thank you. And I take it from council that there is a consent on that
Yes.
qualification. I thank you all. You are so qualified, sir, to answer opinion questions within that area of expertise.
Okay, so given the time that we've spent this morning already, there is one more exciting detour. So before we move to the main body of Mr. Angel's testimony, there's an issue I'd like to address.
Yes.
Mr. Angel, you may not be aware of this, but when Professor Bodway testified on May 30th and May 31st, he stated that before he finished what has been called the present value report on June 30th, 2022, he reviewed an earlier non-final version of your report. And Professor Bodway also testified that he was not exactly sure which earlier non-final version of your report that he reviewed before he finished his report on June 20th, 2022. I'd just like to inform the court that yesterday, during our preparation for Mr. Angel's testimony, it came to light that Ontario had sent Professor Bodway and Professor Smart 3 different earlier non-final versions of Mr. Angel's report. These were dated respectively April 18th, 2022, June 8th, 2022, and June 21st, 2022. Ontario shared these versions of Mr. Angel's draft reports because Professors Bodway and Smart do not have expertise in band trust accounts, but we thought that their evidence would need them to consider band trust accounts. And so they had discussions with Mr. Angel, and we shared these draft reports for them to review. As a result, and Mr. Angel authorized us to share the draft reports with the professors. Now, the reason why I'm telling you all this is Professor Bodway, because Professor Bodway testified that he had reviewed one of these versions before finishing his present value report, and because he was unsure which version he had reviewed, last evening, we produced all 3 versions of Dr. Angel's draft reports that were shared with Professors Bodway and Smart to the parties when we became aware of this. We also informed the parties that we intended to address this issue during Mr. Angel's direct examination. So we're going to have a brief, hopefully brief interlude where we present these draft reports to Mr. Angel and ask him some questions about them. And of course, my friends will choose what they will to do with that in cross-examination.
Were you able to determine the answer to the question with respect to Professor Bodway? Could you?
We did not contact him.
No, I just meant by date.
So
All 3 were sent to.
they were all 3, so it was not clear to us which one he would have relied on.
Thank you.
And so just to be sure, and we don't think he remembers, frankly, which one he relied on. So just to be sure, we just sent them all.
And the 3 dates are April 18, June 8, and June.
21st.
Thank you.
And they're all in 2022.
Yes.
So if we could show, does Mr. Angel have a copy of the April 18th document? We should hand out the copies of the documents. We'll also be providing an electronic copy to the court. My friends have electronic copies. We will also be giving them hard copies.
Last one I have is dated June 22nd. Is that the one you were referring to?
Thank you.
Yes,
Okay.
I thought the date was June 21st. It would be June 22nd, if that's the date on the document.
Thanks.
So Mr. Angel, could you take out the April 18th document?
Yes,
Do you recognize this document?
yes, I do.
What is it?
It's the first draft report that I submitted to you as part of my work on this project.
So I asked that this document be marked as Exhibit 89.
For the
Oh,
purpose
boy.
of, for the purpose of, why are you bringing all these in? Is there something that we need to know?
Yes, so the reason why we're bringing these all in is during the cross-examination of Professor Bodway, he
Yes.
said that he had reviewed a version of Dr. Angel's report
Yes.
before preparing his June 30th, 2022 present values report.
Yes.
And so we don't know which version he looked at, and we wanted to be sure that the court was not sort of misled by, you'll recall that what happened after that testimony is Professor Bodway went to his computer,
Yes.
found a version of Mr. Angel's report, which was actually Mr. Angel's final report from June 30th, 2022,
Right.
and said, I have this version, I looked at this version, it's the most recent version I have, it's maybe not the only version I have. So he was a little unclear. And as my friend had pointed out in his examination, his cross-examination of Professor Bodway, he sort of said, this can't possibly be the document you relied on, it's dated the same date as your report. Fair enough. So we decided to provide these. We just wanted to we didn't want my friend to be concerned that he wouldn't have the opportunity to compare the final version of Mr. Angel's report with the prior versions that Professor Bodway might have looked at. So we just wanted our friends to have that comfort that they could explore any differences between the versions of the report that they might wish to.
Why should they be made court exhibits?
Why should they be made court exhibits? We had thought that, I suppose I didn't expect that people would be concerned about this. It was because we want to be able to take Mr. Angel through them and just have him speak a little bit to what the differences are, why the differences exist, and things like that. One of the versions, the April 18th version, awkwardly contains comments from counsel, and we wanted to discuss some of those as well in direct examination. I know this is unusual given the Moore case. This doesn't typically happen in Ontario, but apparently it happens in BC all the time, as Mr. Rankin's informed me.
Wow.
If I might, I jumped up a couple moments ago because the version that we have been provided is a track changes version, which I think is a lot more helpful if we're going to compare what the differences between the two. So we received the track changes version, and the copies just provided to the court are all clean.
I was worried that you would ask me to compare, or that you would be trying to get us to compare 3, possibly 4 reports, which I'm really hoping doesn't happen.
Yes, and I am also hoping it doesn't happen, but I don't know what my friend wants to make of this.
All right. What do you want to make of it?
So what we're trying to do here is we'd like to just provide some explanation and direct examination for these differences. It's not going to be long and tortured. I don't know the nature of the cross-examination on this subject. More of a high-level description of what happened and why.
Right. Well, I'm always presuming that there are draft reports, which I don't see.
Yes, presumably.
But is the issue to try and understand something from Professor Bodway's examination? Is that why you're going back to these?
I think to some extent. So my friend, Mr. Schachter, had elicited testimony from Professor Bodway that Professor Bodway had relied on an earlier version of Mr. Angel's report that must have predated June 30th.
And if you would be so kind as to remind me, any particular proposition in that report? Is that the issue, that he relied on some statement of fact or statement of opinion? And
I believe there were 2 that were identified in the testimony. One was about the investments that were occurring in the 1850s. I don't remember what the second one was. If someone could look that up for me.
But, okay, and so wouldn't it be shorter if you said, was that in your April 18th report or the next one, your June 8th or your June 30th report? Is that as simple as that?
The problem is that to fully excavate this, the person we really need to talk to is a witness who has since been excused and is back in Kingston. So I'm in a bit of an awkward position because we don't know which version Professor Bowlby relied on. We don't, and I have no idea what my friends want to make of these drafts or not.
Well, couldn't, if there was a proposition from Professor Baudouin that was made in evidence, and he said he relied on Mr. Angel's report, can't one find in Mr. Angel's report where there's support for that, or where that proposition is articulated?
I sure hope so.
But you don't know? Like, isn't that all we're doing? That Professor Baudouin said something, the question across was, where did you get that? He said, I got it from Mr. Angel's report. Next question, I don't see it there in Mr. Angel's report. So you can say, well, it was in Mr. Angel's report, this version.
Yeah, that's definitely a way to do it. I unfortunately, I haven't gone through that exercise. I didn't think this would go quite this way. So.
Oh, okay. So and the only other question is, what was your plan? Just to put the 3 in and say,
So my plan was to put the 3 in and say, what were the changes between this version and the final version? Why did those changes happen? And then take him through a couple of comments that he might want to comment on and just discuss the drafting process in a
okay.
very hopefully contained way.
But we're only interested in the propositions made by Professor Baudouin, right?
I would think so. I don't
Okay.
know what my friends are interested in.
Okay, well, we might move that to the end of your examination and see if we can solve this. Is there some reason this is necessary for your purposes, Mr. Schachter?
Well, keeping in mind, we've only had it for a couple of business hours. I've already identified areas of cross-examination on the changes.
Mhm.
So, whether they go in as exhibits or not, I'll be taking the witness to some matters. Perhaps my friend will deal with it. Yes, is this, I sort of see these additional documents as kind of late in the day, but I think I can overcome the prejudice, by just dealing with it on my feet. It's not something I need to get a reply report or anything. And there's, so I'm kind of neutral about it, but I do think that whatever the court should, I think the court should have the one that, if we're going to talk about changes, have the track changes version in, or even if it's marked as a lettered exhibit for the court. I don't want to complicate the court's life at all, but if they're in track changes, it's easier to follow. And if they're marked as, whether they're marked as an exhibit or as a numbered or lettered, I don't think it matters to me.
Mr. Gover?
I'd just like to make it clear that in my view, what you receive in way of draft reports ought to be presented in track changes versions. I understand from what we received electronically that they're available. And that's going to make it readily apparent and understandable for us what the changes were, so that there won't be any misapprehension in that respect. My submission as well is, to be clear, these should be lettered exhibits as opposed to numbered exhibits, so that we have a common understanding about the use that can be made of them. The real exhibit is Mr. Angel's report as opposed to drafts, but the drafts may be used for limited purposes, including cross-examination, to illustrate points that I know Mr. Schachter and I have already discussed.
Thank you.
Thank
you. Okay, so I have to say that when I look at 3 separate reports and think that I would have to go through looking at the differences, I would prefer track changes.
Sure.
version. And if there's an extra one, I could have it. And if you have to print an extra one, we can perhaps do it at another point in your examination. Does that work?
Sure. So in terms of the track changes, there are 3 versions of the report and there are different ways to do track changes. So do you want them tracked? April
The most
18th?
helpful way.
Okay. I guess,
I think it should be tracked the way they've already produced them to us.
Okay.
already.
okay.
What do you have? Color coding or something?
So just, yeah, they are color coded just in, so the court understands the tracking, because they're you
Mhm.
track between 2 points in time. The way they were produced to us, so the April 18th version is tracked to the June 8th version. The June 8th version is then tracked to the June 21st, 22nd version.
Mhm.
And then the June 21st, 22nd version is tracked to the final. So it's that kind of tracking.
Right. It's an iterative process, but at the end of the day, there's a single volume with all of those changes.
Those are 3 separate tracks, track changes versions.
In a single volume?
They're 3 separate documents.
Ah, okay. Got it.
That would be a disaster.
I have found that myself.
We're fine with these drafts going in as lettered exhibits.
All right.
So let's go with that.
So why don't the ones you make as lettered exhibits be the tracked ones? Or unless you want to put these in first?
Yeah,
Okay,
I think I'll put in the cleans and then the tracks, if that's okay.
all right, go ahead.
Okay, so could we have the one that Mr. Angel has reviewed marked as, I think it's exhibit DD? That would be
April
the April 18th.
Okay. Correct, that would be-
And then if,
Can we just, here, probably-
sure, so this is
call
Eric, oh, sorry.
Or- Sorry, what were you going to call it?
I was going to call it Eric Angel Draft Report, April 18th, 2022.
Very good, thank you.
Okay. And then could we also put in as exhibit EE, the track changes version that compares the April 18th version to the June 8th version? And that would be exhibit EE. We didn't print those. Okay, we'll have to print those later. So
right. Let's
we'll
do,
start with the cleans is what we have.
Right,
Okay, and then Mr. Angel, could you look at the June 8th draft?
Yes,
Do you recognize this document?
I do.
What is it?
It's the revised draft of the April 18th report that I submitted to you on June 8th.
Okay, and so I asked that this document be marked as exhibit EE. And then if you could, Mr. Angel, if you could look at the June 21st or June 22nd draft. Do you recognize this document?
Yes,
What is it?
it's a further revised draft that I submitted to you on June 22nd.
Okay, and I asked that this document be marked as exhibit FF. All right, so let's start by looking at the April 18th, 2022 report. And I realize I don't have time here with me, so I know we're getting close to lunchtime. Certainly I'm feeling that, but if someone could let me know when that's close, I would very much appreciate it. So I'm going to ask you some questions about this April 18th, 2022 draft report. Is this draft substantially different from your final report dated June 30th, 2022?
Yes, it is.
How?
Oh, it's substantially revised. The bulk of the work that I did between April 18th and the final version was by way of analysis captured in tables. That's typically how I work with these projects is there's a huge mass of data, so I like to organize it into different tables to help me understand what patterns are. And a lot of the questions that came out of the April 18th report, the bulk of them were questions of clarification. When did this happen? How much? Very, very fine-grained questions of, you know, how much interest was paid in such and such a period of time. was it compounded or not? And I simply wasn't able to answer those questions as of April 18th. I hadn't done the very detailed work. So between the 18th and the final version on June 30th, I prepared quite a few tables, a list of all the different investments, the debentures that were held in the 1850s, the date when all the different First Nations accounts were opened, which I had to go through the accounts one by one for like several thousand pages. There's no alternative to that. An analysis of the two core treaty annuity accounts, just looking at what was happening, the activity in those accounts from one year to the next. And then looking at the specific band accounts, I did a sample of those to try and get a sense of what was happening to monies that were sitting in the accounts. I think there was another table. Oh, right. Examples of what kind of expenditures there were out of the band accounts. So, a really significant amount of work took place. But on top of that, what I found from the feedback from the April 18th draft is that I had not done an adequate job of explaining how those accounts operated. Clearly, my clients, the legal counsel and the expert economists who reviewed it weren't grasping what I was trying to explain by way of how the accounts operated. So I rewrote some of that for the June 8th draft. And then I substantially revised the section on the treaty accounts, the annuity accounts for the June 22nd draft. And other changes that were significant. There was a section at the end, a discussion section where I attempted to speculate hypothetically what on a couple different scenarios, what might have happened if annuities had been paid. I was always uncomfortable with that section. I'm an historian and I don't find counterfactual reasoning very easy or appealing to do. And I recognize the importance of it for this case. And so I did my best to try and speculate as to what these scenarios might have looked like, but I was never very happy with them. And as the time approached to finalize the report, I spoke with counsel and we discussed it, and I removed that discussion section from the report. Now it looks like I'll have to address it after all, so so be it. Just trying to think if there was anything else. There's a section in there just on Crown control of revenues, and I'll go into more detail on that later. But basically, what happened there is that we went back and forth in terms of. Well, I wanted to put it in an appendix because I didn't feel it was terribly well developed. But then I saw that it could.
Sorry, which one did you want to put in?
Oh,
the
my
appendix?
apologies. The section at the very end on Crown control. Yeah, because it consists mainly of recitation of statutes, right? So, and then I thought about it in terms of the flow, moved it back in. I didn't change the substance of it very much, but I just moved it around between the appendix and the main body of the report. I may be forgetting other substantial changes, but I think that sums it up reasonably well, I'm sure, under cross. So I'll have to account for more than that.
So you said you removed the discussion section after conversation with counsel. Did you decide to remove that section?
Yes, I did. Yeah,
And that the discussion section is what you call the counterfactuals.
that's correct.
Thank you.
If you look through these reports, they'll see this version, the April 18th, 2022 version, you'll see there are multiple comments from counsel, from me, in fact. Did you consider these comments?
Yes, I did. I considered them very closely.
And broadly speaking, what did you do in response to these comments?
Well, I spoke to you on numerous occasions to try and understand, to get a better sense of what the comments were about, and made quite extensive lists. Some of the comments were of the nature of be consistent about what terminology you're using. And that's what led to, there's a glossary in there of all the terms that are used. And so that came directly out of a large number of comments in that April draft that said be consistent. So And then there were a lot of comments in there about clarification. So I spoke to council to make sure I understood what he needed clarified, because one of the challenges with this is that I've spent so much time with these trust fund accounts that I just assume that other people, if I explain it the way I understand them, I assume that other people will grasp what I'm saying. But what emerged over the course of many conversations with council is that the picture that's in my head of how these accounts operate and function, I simply wasn't translating it very effectively. So we spent a lot of time just trying to get to the root of what the confusion was about there. And I think at the end of the day, I was able to draft something that the economists could rely on and that council understood what I intended. And so I felt comfortable with that, but it took a lot of work.
I've been politely informed by Mr. Rankin that it is past 1:10. So typically we would break around now.
I think it's a good idea. Thank you. Just let me catch up for a moment. All right, we'll break. Do we need an hour 15, an hour 15?
Whatever time suits.
So just in terms of a preview,
Yes.
The rest of this section should take about 20 minutes.
Mhm.
And then the remainder of Mr. Angel's testimony, less the slides that we are not going to have him testify to, I'm going to project it will take between half a day and 3/4 of a day. So in terms of meeting the overall schedule, I don't know how long my friend's cross is anticipated
Okay.
to be.
We'll have a chat. Okay, so we'll break now till 2:15 is only an hour. Does that work? Mhm.
Maybe a little bit more. Need to run out and get lunch.
Such a big team. Why aren't you ordering? Okay, 2:30.
Sure.
All right.
All right.
Stay here.
For recess until 2:30.